But there are other forms of leverage, and particularly now, a lot of those take the form of technology. I did want to deal with one that's not very popular with junior practitioners at the moment, and that's this: dictation. It seems old-fashioned for lawyers to sit there, speaking into a little tapey thing, and someone then gets it at the other end and they type it out. A lot of lawyers think that because they can type fast, then they should just do all their own typing. Well, it's not true. It's simply not, and I'll explain why. The dictation of a letter, if I want to write a one-page letter, I can get that done in 30 seconds. Now, otherwise, if I'm typing the letter myself, what I have to do is I have to go to the file, I have to open up the relevant system in my computer, I have to find the address of the person I'm going to, I have to make sure that my document is conforming with the style that the firm produces, or open up the precedent. All of that could take 2 or 3 or 4 or 5 minutes. Doesn't seem like a lot of time. Multiply that by 20 letters every day, 5 days a week, across 48 weeks of the year, and it does start to add up. If you can produce 5 letters by dictation in the time it takes you to produce one, just with all the stuffing around that comes with a letter, sure, you can type it out. I mean, I can type at 60 or 70 words a minute. I can type a letter if I need to, but what I know is that it's far more efficient for me to dictate the letter, for my secretary or personal assistant, if I've got one, to do that other work that I don't need to weigh into. They can look up the address, they can get the file, they can make sure all the details on the side of the letter are fine, and that way I am free to move on to the next task or the next call or the next letter. Again, something that my secretary can't do. So if you've got a secretary and you've got the opportunity to dictate, don't freak out. Yes, it's weird speaking to yourself, but I can tell you it's weird I'm speaking to myself now. It took me a while to get used to as well. Just take a leap of faith, try dictation. It does get easier, it gets more efficient, it gets better, and you will be benefiting your clients ultimately by doing it. It doesn't mean you dictate everything. I still will write a short email or a letter sometimes. I'll certainly do some amendments. More complex documents, I know a lot of people have trouble dictating if you're doing pleadings or contracts, and by the time you get to the end, you've forgotten what there was at the start. And so things like that can be a little more difficult, but by and large, there are a lot of things that can be dictated. It's an important form of leverage to get work out the door more efficiently than it might otherwise be getting out. So that's the second form of leverage that we're going to talk about today. The third one is the utilization of technologies. Now, this one's pretty straightforward. You might be able to do something more quickly on a phone or using a computer. Telephones, obviously, are now more sophisticated than they used to be. Technology is an important form of leverage, provided it's being used appropriately. We'll take one more obvious one now. It used to be the case that lawyers wrote down all of their time, some lawyers still do, on a paper sheet, and it was eventually tallied up at the end of the month, or it was entered into a system by a secretary or a data entry person. Most law firms, not all, but many law firms now have lawyers entering their own time. How is this more efficient? Because it kind of goes against what I said before, that a less cost person could be doing the task. Well, what it means is that the time entries are of higher quality. It means they generally need less editing. It means the secretary isn't spending time trying to read a solicitor's writing, which we all know can be a bit of a nightmare. And what it means is that that time is being captured immediately. A bill can be issued immediately. The system captures it straight away. The firm knows where it stands financially. All sorts of things are happening behind the scenes by virtue of the solicitor entering their own time rather than waiting to the end of the day or the end of the week. The other thing is this: the time is being captured more efficiently, and it's also being captured more accurately. So the number of benefits outweigh the possible cost of having a solicitor entering their time by themselves. And that is a form of utilising technology to have more things done in a shorter space of time and avoid the double handling that was occurring when people were writing out their timesheets and entering them manually. So technology, an obvious form of leverage. Just make sure with technology that it's actually speeding things up or making things more efficient. A lot of people use technology in a way that they seem to think is more efficient, but there's other ways of doing it that are in fact faster. Marking up documents is one. Sometimes it's more efficient by hand, sometimes it's going to be more efficient doing it on your computer. Use your judgment. You are capable of determining on any given task what the most appropriate course is, and then just get on with it. The last one I want to have a talk about today is precedents. Now, precedents are a great form of leverage, provided they're used properly. Precedents are an ability of you or your colleague or your secretary or your paralegal to be able to get a document out in rough form, and I say rough form for reasons I'll come back to, in rough form that meets all the basic requirements of what it needs to. This might be a contract for a residential conveyance, this might be a commercial lease, this might be a liquor application. There's all sorts of things that can be done using precedents. There's certainly a raft of standard letters that can be done. Winding up applications can be precedent based, as can bankruptcy applications. Some forms of litigation can have precedent use available, in particular with letting clients know what's going on. However, and this is an important however, precedents aren't to be used as a crutch. While they can be an important form of leverage, if they're used wrong, they'll be a complete and total disaster. Time and time again, I see people who've used precedents and have not actually spent the time reading them, and you end up with things in the documents that make no sense. When asked why, they just say, oh, I just used the precedent. That's a rubbish excuse. Don't let precedents be an excuse for you not doing your job properly. Even if you're using precedents, you've still got to read the letter, you've still got to read the pleading, you've still got to read the contract, and make sure you're doing your job as a solicitor for your client, that the product you're producing is appropriate. So, that's the forms of leverage I want to talk about today. There's plenty more. Really, leverage is just any opportunity you have to generate your work or your firm's work more cost effectively, more efficiently, more quickly, so that things are getting out the door faster and involving less time spent by individuals in the firm. That's what leverage is. Hopefully you now have a good understanding of it if you didn't already, and I'll see you next time.